Evicting a tenant from one of your properties is never easy. It's not the thing you want to be doing, and it certainly doesn't make your life any easier, but it does have to be done sometimes. Now, this is easier said than done, especially if you're not experienced at this and don't really know what the stages are. So in this video series, I'm going to answer all of your questions about residential evictions in the state of Pennsylvania. I'm Jennifer Rulins, landlord, educator, advocate, and broker of One Focus Property Management. I'm starting today's video letting you know that it's a 4-part series on how to evict your tenants in the state of Pennsylvania. So I've been managing very large residential portfolios in Pennsylvania for the last 18 years. And while I've never counted exactly, I estimate I've got about over 200 evictions under my belt. So we're certainly not strangers to that here at One Focus. It's not our favorite activity, but it is something that needs to be done. Now, I manage this process every day without the help of an attorney. However, it may very well be that you do need the assistance of an attorney in your eviction. Now, this video does not constitute legal advice, nor is it intended to be. I am not a lawyer. I'm simply sharing with you how we manage evictions here at One Focus Property Management and how you can start to learn a bit more about the stages of the process and what they mean exactly. We'll start by talking about working with your tenants. So whenever I bring up the topic of eviction, landlords share with me, I'd really rather work with my tenants than go through this legal process. And I completely understand, and there are certainly situations where a short-term payment plan would really make all the difference and is the right solution. This video is made with the assumption that you've exhausted those options or that those options aren't acceptable to you based on the facts of your case. And so this is moving forward, acknowledging that we don't have a way to work this out without legal intervention, and we really need to enforce this lease to maintain your rights. The next step I would share with you, and I know you want to get into the nitty-gritty, but it's to tell you to calm down. I work with landlords every day and I know the feelings that you're feeling. So it's really important that you separate the facts of your case from the emotions surrounding it, both yours and the tenants, because certainly if you're talking about eviction, the tenant could be exhibiting some emotional distress to you. And so what I want you to know is you have rights here, you have a lease, and this is a business arrangement. You have not adopted this tenant and they are not your responsibility to house and take care of forever. That being said, the most common trap a landlord's going to fall into through the eviction process is the one of righteous anger. Well, what's righteous anger? Well, righteous anger is anger based in a feeling of being righteous. It's when you say things like, it's the principle. So when somebody's lying to you or in some way not performing in accordance with the social contract, much less your legal lease contract, it's infuriating and it's really difficult for most landlords to manage that righteous anger. So at this part of the process, I want you to be cognizant of it. I want you to think about it, and I want you to stay focused on the facts of your case and what you can control. You cannot control the actions of your tenants, what they say to you or what they do. You can only control your own actions and reactions. You're going to be much more successful if you can let go of that very natural and understandable righteous anger. The next step in the process is not filing the notice to quit. No, before we do that, I want to make sure you have your documents in order. Now, why do I want you to do that? Well, because if you're going down the road of legally evicting them, you're going to have to produce things like a lease, a tenant ledger, things like that to justify your case. So let's make sure you're working on that now. You have those pieces of evidence and they're ready to go. So let's start with just very basic things like your lease. You want to make sure you have your lease available to you and then it's signed by all parties. If not, you really need to get your hands on an executed lease in order to stand your ground in court. Another thing you might want to prepare is if your complaint is about non-payment of rent, you want to put together a ledger. Now you might use a software system where all you have to do is hit print and it prints out an account history for your tenant. But if you don't do that, this could be a handwritten thing on a piece of notebook paper that just details their account. So I would go back to the last time they had a $0 balance and then show every rent charge or utility charge, whatever they've been charged, and reflect any payments on there chronologically using details like whether it was cash or a money order. Use those details and construct that ledger so you have some proof, some documentation of what you're claiming, which is non-payment. Now, if your claim is not about non-payment, or in addition to non-payment issues, you're having non-compliance issues. So that's people who are maybe moving in other people on the lease, moving in animals, causing property damage, not caring for the property properly. Any of those things could be non-compliance of the lease. But what the courts will call this is an immaterial breach. So it's immaterial, not material or not money related. So when you have an immaterial breach, that's a little bit different, and it's treated a little bit differently by the courts, and we'll get into exactly how soon. But when it comes to proof, you have to do a bit more than just have a lease and have a ledger. You need to have some proof of that this is going on. So if you want to prove that there's property damage occurring at the property, animals are destroying the property, the tenant is destroying the property, you're going to want to have some photos and documentation, attempts to get this damage fixed or taken care of documented, so that you can show to a judge in the court that you have tried everything and that this is the exact situation that you're facing. Now, don't try to show the judge your phone. In fact, some courthouses don't even allow you to bring your phone into the building. So you're going to want to have everything printed out on paper so that you can hand it to a judge to see. When impossible, those photos need to be in color. If you're going to try to give a judge a link to watch to a video, good luck. You might consider putting that on an iPad as something that could be displayed more easily to the judge and then, of course, to your opposing party. So at this stage of the game, we're just gathering everything we need, making sure our documents are in order before we proceed to the next step. Okay, now we're ready for the next step in the process, which is posting a notice to quit. So a notice to quit is a required document in Pennsylvania that technically starts the eviction process. It's notice to your tenant that they need to make good on this provision of the lease within a certain amount of time, or you're going to proceed with legal action. Now, your lease might include a waiver of the notice to quit, and I'm going to address that in the 4th video in this series. But for now, we're going to assume you don't have any such waiver, or you're not able to use the waiver in this case. So, the notice to quit is simply a document. It will have the landlord's name and contact information, the tenant's name, the property, and the exact issue of what's going on. So it'll say this is a notice to quit or remedy the issue in so many days. So if it's non-payment, it's to pay this full balance consisting of these fees on or before this date and by this method. It really lays it out. If it's another breach of the lease, it would say what's going on at the property and which clause of the lease this is breaking. So you're going to be clear on there what you're looking to have changed, because what this notice is supposed to do is give the tenant a chance to fix it before you file for eviction. Now, how long of a notice do you need to give to these tenants? Well, if it's about money, so if it's about non-payment of funds, 10 days. You need to give notice 10 days before you take legal action at the courts. Now, if it's about immaterial breach and does not include a money complaint, well, that's going to be different depending on the length of the lease. So if your lease is 1 year or less, that's going to be a 15-day notice to quit. If your lease is more than 1 year, even by just a day, then you're required to provide a 30-day notice to quit. So you would need to give the tenant 30 full days in that case to fix the immaterial breach before you're permitted to proceed on with it in court. You see now how a lease in excess of 1 year has consequences beyond just the term of the lease and your requirement to provide the property for that amount of time. So something to think about when you're writing a lease longer than 1 year. Posting the notice to quit is deceptively simple, but it's something you might not think to do. So in Pennsylvania, you're required to post it on the property door, open-faced, so not folded, turned around, or in an envelope. In an apartment building scenario, this can seem really excessive and like it's exposing the tenant. And while it is, this is the Pennsylvania Landlord-Tenant Act. So we will drive out to the property, post it on the door, Step back, take a picture of the posting where you can clearly see that it's the property, maybe it has a street address or something, and we make sure to timestamp that photo. What we want to be able to do is prove to the judge in court that we've complied with this part of the Landlord-Tenant Act and we've posted the notice to quit. After you've posted the notice to quit and taken a picture for your files and evidence, now you mark your calendar and wait. So pay attention. Did you need to give a 10, 15, or 30-day notice? Well, mark your calendar for the day after that period has passed. So in the case of a non-payment, I would typically mark my calendar 11 days after I posted the notice. There is an exception to this though. For most courts in the state, this isn't universally applied because I've had hearings all over the state. In most courts though, if the 10th day of that period or the last day of the notice period falls on a Sunday or a holiday, they'll typically extend that notice period by 1 day, not permitting you to file on, for instance, a Monday if it's the 11th day, if that Sunday was the 10th day. So in that case, you would wait until Tuesday. This is when you start getting involved with the courts once we reach that date. But I'm going to save that for next week's video. We're going to get into the nitty gritty. How do you file a landlord-tenant complaint? What can you expect in the hearing? And then of course, what happens after the hearing? And if you actually have to go to physically taking possession of the property, we're not going to skip one single bit. I hope you'll like this video. Give us a subscribe and share with another landlord friend of yours. I love making these videos for you, and I hope I'll see you next week.